seated. All right, we're here, part 2 of HOA Day. We are here on Gallery versus K. Hovnanian et al. It's our number CV-24-0252. Everyone here is experienced counsel. You know, you have 20 minutes each. You may use whatever time you wish. Hold on. One more thing. We do not have Justice Cruz here today. She's recused herself of the matter, and so instead filling in, we have former Justice, retired Justice, John Plander came up from Tucson, so we thank Justice Plander as always. So, Mr. Willenchek, you are ready to go. Please.
I'm having a little trouble with my ear again today, and I apologize if, to all of you, if you could either speak up louder.
Sure. Having that, no
part
worries.
of the problem of getting older.
I'm happy to always to scream at counsel. Sure.
Okay, I'll be the first. May I begin?
Sure.
Thank you, Your Honors. May it please the Court. I'd like to make just a few points here today and clarify a few points before I'm done. The first point is I don't know what this Court of Appeals did, quite honestly, by saying that 33-2002 somehow expressly granted an implied warranty right. I've been doing this a long time, but that's a new one on me, how a court could do that. I couldn't even understand if they tried to say it was impliedly into the statute. But to say it's expressly part of the statute, I don't understand that. And what they said was the reason is because basically they couldn't figure out what the purpose of the statute would be without that. But there is a purpose to the statute. There are other causes of action, which in fact in this case were brought. There was a negligence claim that was brought and dismissed. There was a breach of contract claim that was brought and dismissed. So there are other causes of action.
May I stop you there, Mr. Willenchek? As far as the other causes of action, what would the breach of contract be based on? Is there? I mean, there's no contract.
CC&Rs probably.
Well, so the CC&Rs considered a contract between the HOA and the vendor builder?
Well, that's a great question. It's never really been fully answered. My recollection of the case law is that the CC&Rs are generally considered a contract between the HOA and the owners.
Right.
People have extended that loosely to say it's a contract and therefore somehow it applies to everybody. But technically, that's what the case law says.
But I mean, you have to have an implied warranty has to result from the construction of the new homes or entity, I guess, but also from you have to still have privity of contract, and that's why I'm kind of focused on what the privity of contract is between the two. And if you don't have a contract, then you could file negligence, I would assume. You're not precluded by the economic loss doctrine from then proceeding along those lines. I mean, do I have that right? And I'm only interested in that because I'm trying to think what causes of action are out there.
Well, we did not, let me answer that in a couple of different ways. We did not take the position below that the CC&Rs were not a contract that applied. So I hope that helps a little bit. We argued instead that there was no breach of that contract that they could identify, and the court agreed with that. They haven't appealed that. So I do believe, although I say it earlier, it is murky, I do believe that the CC&Rs probably would be considered a contract by the declarant, who is usually the developer of the common area. And we didn't take the position that it wasn't in this case. We just argued.
Assuming it is a contract, does the implied warranty a term of that contract? Is it in the CC&Rs?
No, because again, there is no, let me just say this flatly, at least so far until this court changes it, if it chooses to do so, it can, of course. But there's no implied warranty in over 45 years, as you know, that's ever been granted to an HOA. And that was our simple position. It's only been granted in a limited context to purchasers, subsequent purchasers without notice. An HOA, by definition of that, could not be included in that because an HOA does have notice of the defect when it's assigned or otherwise. So our position is this court should never change the sanctity of the implied warranty, which was developed for what? For public policy purposes, for owners of new home construction, as I read the case law since Columbia Western and Richards and so forth. It was, and even in Zambrano. And frankly, in Zambrano, now that I think about it, I think with all due respect, you, Your Honor, said that the statutory scheme, which is similar to this in the sense that it has conditions, 12-1361, does not create a cause of action. You stated that in that case. I don't believe that this statute creates a cause of action either. It's very similar in that it's conditions in order to bring an action.
But,
it has nothing to do with creating a cause of action.
Mr. Wilenchek, you may know as in my previous life I was a constitutional ambulance chaser.
I'm aware of that.
And if I saw this language, if I was wondering whether there was a right of action, I would rejoice. I would say absolutely I would. And to
why
get
is
to the language of Section 2002, I would be very, very happy.
If you were me?
I would, if no, not if I were you. Right.
This litigation.
As a constitutional lawyer, you would be happy.
But getting to the point of the breach of contract claim that the chief was asking you about, the language in subsection A says, in addition to any requirements prescribed in the community documents of a homeowners association, in addition to.
Yes.
A homeowners association may file a homeowners dwelling action only after the following have occurred, and then in subsection B, it refers to the right of the association to bring a homeowners association dwelling action. I don't know what more you need to establish a right of action.
Well, let me be clear on this. We may be saying the same thing, I'm not sure. Establishing a claim, which is what that does, that statute, is not necessarily equivalent to creating a cause of action. Just as I just said, 12-1361, they argued the same thing in Zambrano, I believe, and the court, I think Chief Justice Timmer stated, if I recall correctly, that does not create a cause of action. It's no different here. There's no language you're creating a cause of action for an implied warranty. That has to be done by the court, in my judgment. Court creates the cause of action.
What is it not? So, first of all, the legislature used the term action twice in these provisions.
Right.
But also, why is it not a construction defect action? It may not be an action for
It very well
warranty.
should be a construction defect action. I totally agree with that.
So
it just doesn't
why-
define whether it's negligence, whether it's breach of contract, or whether it's an implied warranty. It doesn't define any of that. The legislature never defined any of that, and there's not one word I can find anywhere. Legislative history, looking at, how they adopted the statutes, that in any way the legislature intended to say this creates the implied warranty that was created by this court for a very specific group of people.
How is the language in 12-1361, which is part of the PDA, but it's incorporated into the HADA, I guess?
The definition of construction defect is incorporated.
Yeah, and subsection 4C talks about the failure to adhere to generally accepted workmanship standards in the community. How is it any different in substance from an implied warranty of workmanship and
It's completely
habitability?
different. That actually, in my judgment, I'm glad you asked that question, Judge, that actually defines, to me, a negligence cause of action. That's exactly what a negligence cause of action is, to answer your question. It has nothing to do with an implied warranty claim. Implied warranty claims, again, and I think you know this, but I don't mean to sound, but it was very specific when the court created this to apply only for a reason to new home construction, new home purchasers or subsequent purchasers without notice. Clearly, that's the key. And again, as my co-counsel there said, I have no problem with any of that. That should be what the implied warranty is for, the individual owner. But what this court did below was to usurp, was to actually not only create a cause of action that didn't exist for implied warranty that the legislature never intended or said, but it's worse. They actually usurped the right of the individual owner, if you look at this in context, from bringing their own implied warranty action that you granted them. That is insane to me. And to do it by implication and say it's actually express, there's not one word saying implied warranty in there. And that's a very specific cause of action.
Yes,
you can sue for construction defect. I'm sorry.
What would happen if because I don't see that I see your argument, but if the homeowner association brought the action based on damage to the homeowner's owned property, I guess that wouldn't prevent the homeowners from simultaneously filing their own action, would it? And then what would happen?
I disagree. I think it does as a practical matter. Think about that. It's a good question. But think about that. So you have two competing causes of action with two potentially different results. One may want to settle, one may not want to. It would create a complete hysterical nightmare.
Well,
if that were the case.
Doesn't that answer seem to support the idea then of your position that there is no statutorily created implied warranty
For the HOA.
for the HOA?
Correct. Now, can the HOA bring an action, including a condo association, which fits under the definition of 2002, 1, et cetera? Yes, and that answers, I think, the question you were asking in the last session about what if the association jointly owned, if I understood it or heard it correctly. The answer to that question is really very easy. Then that becomes the loft case. That becomes in joint ownership a condo under the Title 12 statutes, which specifically allow an HOA directly under 1242, whatever, 4, I think, specifically allows a condo association essentially to take the individual rights of the owners because it's all jointly owned, and it expressly allows the condo association to bring that action in its own name for two or more owners, or if it's jointly owned, which is what 2001 talks about. So that's a condo scenario, and that's what loss was all about. Loss is a condo, and it's not to be used indiscriminately, as some counsel do. It's a very specific case dealing with condo association. And so I don't think we need to deal with that. That's covered. I do want to address something I think Justice Montgomery was talking about, to clarify, if I may, when you raised the CC&Rs. I have to beg to differ, with all due respect to you. I don't believe that the CC&Rs have an obligation to maintain anything as I read them. I believe that Section 8.1.7, which I think is the provision you're looking at, doesn't require it. It is not mandatory. It can be, it's permissive, that the association, in order to maintain uniform appearances and so forth, has the right in that scenario to go in, if it's not being maintained appropriately and the owner refuses to do so, to then, for the benefit of the community, fix it, and then charge the offending owner the money for that and obtain a lien on the property if they don't pay it. That's not having anything to do with a claim against the original builder or declarant.
Can I ask you a question with respect to that, too? And this kind of relates to the nature of this particular community as well. I get what you're saying.
And by the way, can I add to that, please?
Yes.
I have it in my notes somewhere, but the owner is specifically, I think it's paragraph 3. Give me 1 second, 3.7, if you look at it, that makes it clear that it's the owner's responsibility to maintain their property, which it is their property, the roofs and common walls.
But with respect to the particular property here, I mean, there are four buildings with 18 units each. So who owns the roof in that regard? It seems to me...
The owner owns the roof.
But which owner?
On their individual property, they own that portion of the roof.
And within this, 4 buildings, 18 units. So are these fourplexes? Are they single story?
No, I think they're like fourplexes. That's my recollection.
Is there one unit on top of another?
I don't believe so.
Okay. And in that regard, though, and I'm trying to find 3.7 really fast so that I can follow the comparison you're making. 3.1.7, or no, 2.7. I'm sorry, give me just a moment. Maintenance of lots. Each owner of a lot is responsible for maintaining, repairing, and replacing its lot and the dwelling unit landscaping and other improvements.
And the lot is going up vertically.
Right. And then, and reading these all together, when I go down to 8.7, though, and you quoted some of the language already, but it does go on to then say that the association shall promptly repair or replace any damage or destruction to the dwelling unit or contents thereof caused by such entry or work to ensure the uniform appearance.
That's right.
and I agree, it doesn't say the association shall, it says it will from time to time as it
It
may
may.
determine appropriate. Paint the exterior of the dwelling units and repair, maintain, and replace the exterior walls, stucco, facade, roofs, or other surfaces. So, and this is similar to I think the points I was making in the other case too, whether or not, given this particular relationship between the HOA and the unit owners, are we in a scenario where recognizing that there could be a dwelling cause of action under these facts exist? And I get the argument that you're making too, and it makes us a bit of a conundrum. Because if I just look at the statute, and so I'll defend the Court of Appeals a little bit here. If you just look at the statute and read it down, there are multiple references to dwelling action, in addition to what Justice Foley
Right, but
was-
you got to go back to what a dwelling is.
Right. And you go back to the dwelling, and I know your argument there is looking at the conditional part. Before we get to that.
Well, it has to be owned by the HOA or jointly
Right.
owned.
You know, I want to press pause on it just for a second, because there's a discussion we can have on that too. But with respect to 2002, you know, if I just read through and I keep coming across a HOA dwelling cause of action, and I get down to A3 that references at the time of commencing a dwelling action or amending a complaint to add a cause of action for a construction defect, I run across that language again. And then in B, if there's an issue with statute of limitations affecting the right of the association to bring a homeowners association dwelling action, and then I go to, well, what's a dwelling action? And then I go to, well, now,
What's a dwelling? And then the dwelling incorporates the construction defect. It's very confusing.
Correct. But, you know, so I guess if I understand your argument correctly then, and it relates to Zambrano, and I'm not so sure we needed to say in Zambrano that the statute there didn't create a cause of action.
I think that's what it said.
It does. I don't know if we needed to say that there, given the facts we had in that case, but be that as it may, and I don't want to take all your time. If I look at this at the repetition of dwelling action, and I look at the reference to construction defect and how that's defined, it doesn't seem to be the clear distinction I understand your argument to be making. What am I missing?
I'm not following the last part. Give me that again.
That you know, the distinction that you want to make, that the statute doesn't create a cause of action with the repetition here of a dwelling action that is defined. That's what I keep tripping over.
It doesn't, I can say this as simply as I can, it doesn't create any cause of action. If it did, the legislature knows how to do that. It could have said implied warranty, and it nowhere says that, right? It didn't create that. What it created was a series of conditions similar to 1361 et sec. That you have to go through that are probably similar to what's in the CC&Rs, to be candid. I think there's very little distinction in this case. And that's all it does. And only if you do that may you then proceed to then bring a cause of action if you have one. And as I said, there are causes of action that they brought here. They just didn't succeed on them from the merits and haven't appealed it. So this case is a good example of that. They did bring those causes of action for breach of contract. They didn't lose on the basis that we argued that there's no contract. They lost because they couldn't show a breach of any contract specifically.
Was the negligence claim in this case based on the subsection we discussed earlier in Section 12-361 4C? Was the negligence claim based on that or something else?
Well, I think it was because there's no economic loss rule involved to an HOA that has no contract. So I think that's the only answer I can give you. I can't answer for them, but I believe that's the only basis that they have. And again, I think it defines negligence.
Well, it doesn't say that.
No, it doesn't say implied warranty.
No,
right?
but it sure sounds to me more like an implied warranty claim than a negligence claim.
With all due respect, I have to really disagree with you.
Okay, I hear you.
Respectfully.
I hear you.
I think it specifically talks about common things and what's standard. That's actually the exact language you use for negligence, not for an implied warranty. There's no language that I've ever seen in any implied warranty case that uses that language at all. And I'm familiar with all the implied warranty cases. Maybe I'm missing something, but I don't think so. There's no language like that. The implied warranty, again, was a creature of law that's rooted in contract, which I agree is confusing, but there you go. And it is this court's creation. Why? for public policy reasons that do not apply to an HOA. You cannot tell me that an HOA has the same reasons that support an implied warranty for an individual. It's sophisticated. It does expert reviews before it accepts under the quitclaim. It has a fiduciary duty to owners to do that. And it can negotiate freely and sophisticated in a sophisticated way with the declarant. That's not present in the cases that created the implied warranty. Just the opposite, and that's why it was created. It doesn't apply in any way to these guys, and they're trying to do it for reasons in the short time I have left that really have nothing to do with the law, in my judgment. It has to do with plaintiffs' counsels who want to bring an action easier for one HOA than dealing with a bunch of clients. That's what it's really all about. It had nothing to do with the law. The court had no business in stating that it expressly adopted an implied warranty claim. I submit the legislature knew how to do that, and if it wanted to do that, it would have easily done so, and it never has done so, said so, implied it, or anything else. And this court should not create it out of whole cloth. Wow, thank you.
That was fast. Thank you, Mr. Willencheck. Okay, Mr. Schaefer.
Good morning, Your Honors. May it please the court. Robert Schaefer on behalf of the Respondent Gallery Community Association. The argument that I just heard was that even if the Homeowners Association meets all the conditions set forth in the declaration and in the statute, they may not bring a claim. That's the exact opposite of what the statute says.
Well, yeah, I'm not, in fairness, I don't know that that's, I didn't take that as the argument. What I took the argument to be is you must meet all of these conditions. You may file a Homeowners Association dwelling action, but as that is defined, that means any action that you could otherwise file. So if you have a breach contract, if you have an assignment of claims, if you have negligence, you can bring any of those. But I think Mr. Willencheck's point is that the statute itself doesn't create a freestanding cause of action. It's simply referencing conditions. So, and frankly, that's my sticking point as well, that you would find a creation of a cause of action in a definitional section that you're codifying an implied warranty cause of action without expressly saying that is a little
there's a lot of
troublesome.
confusion this morning, and I think the best way to cut through it is to go back and look at the initial argument that was made to the Superior Court. The argument was that, well, we have a statute that grants condo associations the right to file a claim, but we don't have a statute that grants planned community associations the right to bring a claim. Ergo, the legislature must not have intended to grant planned community associations the right to bring a claim. But 33-2002 answers that argument because in plain language it says any association, it defines a homeowners association as both a condo association and a planned community association. And it says any association, once you meet these conditions, may file the claim. So that is an answer to the argument that the absence of a specific statute granting standing to planned community associations was somehow intended by the legislature to deprive planned community associations of standing. In other words, the legislature is telling us, no, that's not what we meant when we just had this condo statute out there, but we didn't have a separate statute for planned community associations.
But looking at 33-2002A, the one you just focused on, I mean, when I read that, it seems like the thrust of the entirety of at least subpart A, the introductory part, it says, in addition to any requirements prescribed in the community documents of a homeowners association, so probably the CC&Rs, a homeowners association may file a dwelling action only after all the following have occurred. I mean, doesn't that suggest that the thrust of this whole thing is not to create a cause of action, but to say, hey, if you're going to file something, great, do what the CC&Rs say you have to do, but you also have to do the following.
Yes, and it says they may file.
And then, but what
It's
may
not
they
saying they may.
file?
It's not saying they may file if otherwise
It says they may
permitted.
file a homeowner's dwelling action, which is then defined in 33-2001 subsection 5, which then incorporates, as we've talked about before, the provision from section 12 through 1361. But I think Mr. Willencheck's point was that's all well and good. but it doesn't create, especially expressly, a claim for breach of the implied warranty of workmanship and habitability.
Yeah, let me try to answer
So
this question.
walk us through that.
Yeah, let me try to answer this question this way. There's really two components to this case, right? There's the part of the common area that the HOA owns, and then there's the buildings that the HOA doesn't own but has either a right or an obligation to maintain it, okay? As to the part of the case that deals with the separately owned property, the HOA acknowledges that this is the owner's implied warranty, okay? The question is, does the HOA have the authority to enforce that implied warranty? That's all the case is about. And the statute acknowledges that there's nothing that prohibits the HOA from asserting that claim. Whether the HOA can assert that claim is a question that exists between the HOA and the owner, right? That's an internal question that is addressed by the declaration.
But let me ask about that, though, because dwelling is defined in the statute as, I read it, essentially the common areas. It's either owned by the homeowners association or jointly by all members of the association.
That's condo property.
So that means that everything has to be owned. So an individual owner's lot, I don't see that that gives you a right to bring an action if it's just maybe one homeowners or even set of homeowners in a building. It has to be jointly by all members of the homeowners association. So how do you get, where is the authority that under your argument that
that's
it could
only
be
reading
for,
half of the definition. There's two
well,
parts to the
walk us through
definition.
that, because I'm just looking at the definition in the statute.
Yeah, and it says, this is 33-2001-2. It defines a dwelling as a newly constructed single-family or multifamily unit designed for residential use. That's the first part of the definition. So that would cover individually owned homes. And then the second part of the definition is and property and improvements that are either owned by a homeowners association or jointly by all the members of the association. And that deals with both planned community associations because they own the property, right? They're given it by quitclaim deed. And then we have the second part of the definition deals with condos because condo property is owned jointly by all the members of the association. In other words, they're TIC owners, tenants in common. That's what condo property is.
Are condos in that chapter?
Yes, condos are defined, let me back up. A homeowners association is defined in subsection 4 of 2001 as an association as defined in 33-1202, which are condo associations, and 33-1802, which are planned community associations. So the statute doesn't distinguish between the two. And the argument that I'm hearing is that, well, the legislature wanted to allow condo associations to be able to bring suits on behalf of owners, but they didn't want planned community associations. But that's not what the statute says. The statute does not distinguish between condo associations and planned community associations. It gives both associations the same permission, and that's what the statute is. It's not creating a cause of action. It's giving homeowners associations permission to be the plaintiff, to bring the claim. Whether the homeowners association has the authority vis-a-vis owners to assert the claim is a question that arises in the declaration. Does the declaration give the homeowners association the authority to assert this claim on behalf of owners?
So you agree that the statute doesn't create a cause of action other than the existing maybe common law or other statutory causes of action, but that, if I understand your argument now, is that the statute grants the homeowners association authority to basically take an assignment, stand in the shoes of the
It allows the association to be a plaintiff.
So what if the homeowners decide that they don't want that and they file their own suit?
There's a statute directly on point. It's Title 10, 3304. And it limits standing to challenge the authority of the action of a homeowners association. And it specifically addresses both condo associations and planned community associations. It limits the standing of a party to challenge the authority of the nonprofit association to the members of the association. Okay, so you have a statute in 103304 that says, okay, HOAs, you can take whatever action you want, but only members of the association can argue that you didn't have the authority to take that action. Okay, it doesn't give that standing to defendants. But if you look at 33-2002F, right, this is a subsection of the Homeowners Association Dwelling Action Statute. It specifically uses the word standing, and it gives standing to defendants in Homeowners Association dwelling actions to ensure that the Homeowners Association has met the procedural conditions of the declaration. So whether the HOA has the authority to bring the action for the homeowner to enforce the homeowner's implied warranty, that's an internal question. We cited the restatement in our response to the amicus brief.
The argument that you're putting forward, this doesn't seem to be the resolution from the Court of Appeals.
I think it is, because the Court of Appeals said, the Court of Appeals was responding to the Superior Court's holding. The Superior Court said, okay, there's a condo statute that gives condos the right to sue on behalf of homeowners. There's no such statute for planned community associations. And what the Court of Appeals said is, so what? 33-2002 says that as long as the homeowners association meets these conditions, they may file the claim. It's just a question of, did the legislature intend to preclude planned communities from bringing the claims? The Superior Court said yes. Because there's a statute for condos and not for planned communities, we can infer that the legislature intended to prevent planned communities from having standing. And the Court of Appeals said, no, we just look at 33-2002, and it says that planned community associations, once they meet these conditions, may file. So that's the legislature telling us that, no, it wasn't our intent to preclude planned community associations.
So what's the
from
cause of
bringing
action then
claims.
for you to, for the homeowners association to assert for the property it owns?
Well, that claim is because the HOA owns the implied warranty. The HOA is an owner, and I wrote this down. Mr. Walenchik said that the implied warranty gives owners of new home construction the implied warranty. I mean, the owners of new home construction. The HOA here is an owner of new home construction.
Can you delve down into that a little bit? Because the past cases all say that it arises out of a purchase contract. So you have to have privity of contract as the general rule. No. Well, that's what the cases said.
I beg to differ.
You're
I know
shaking
you
your head
wrote
at me, but
Zambrano,
that's what Loft said. That's what I believe Richard says. And there's two.
Loft said there needs to be a contract, but it's a contract for construction. It's the contract between the builder and the company that hired the builder.
Well, assuming humor but it also may say privity of contract, but there are exceptions to that have been recognized in Lofts, and it was recognized in Richards. But you still need that, and that's why I was kind of struggling to think what is the contract.
So we have a builder entity, which is the Hovnanian entity that was the builder. We have the seller entity, which is the Hovnanian entity that sold the home. The Hovnanian entity that was the seller contracted with the Hovnanian entity that was the builder, right? There was a contract for the construction. Somebody hired the builder to build these homes.
What's the one that involves, I'm just trying to get to the association.
Right.
Of some kind of privity of contract
well, there was no privity of contract in
a successive
Lofts.
Purchaser.
There was no privity of contract in Lofts between the homeowners association and the builder. There was no privity of contract between the HOA that brought the claim in Lofts and the builder. There was a contract for construction in that case, and that's where the implied warranty arose. It was between the builder and the seller. The seller hired the builder to build or to do the renovations.
Have any authority for any cases in which like your client got it from a quick claim deed, which is generally you just take whatever they have.
But that's
no
about
warranties,
title.
No warranties of title, no, I'm just wondering, any authority?
See, we're mixing apples and oranges. A quick claim deed transfers title to property. An implied warranty is not about who owns the property. It has nothing to do with that. It's an apple. We're talking about oranges of implied warranties. And the implied warranty goes to whoever owns the property in the residential context. Here, the builder, if the builder wanted to, think about this. The builder could say, okay, we're going to just quit claim every single one of these homes to the association. And the association will then charge a fee, a membership fee, to the owners, right? And, well, the owners don't have the implied warranty because they don't have a contract with the seller. They just bought a membership. And the HOA doesn't have a contract because it got the property by quitclaim deed. So think about what the effect of that would be. A builder like Hovnanian could build an entire community and create no implied warranty on any of that property.
Well, in
How is
as
that
litigants
possible?
often do with us, that's not what we have here.
Certainly not.
So going back to, I think the questions that the chief was asking, and I've got a question because you alluded to CC&Rs giving authority for their HOA to file suit on behalf of the homeowners. I'm going to ask you a question about that in a moment. What's the basis for finding that the breach of implied warranty is a warranty that applies to the HOA? Lofts and the others, we have some degree of privity between the builder and then a subsequent purchaser, and that's in the facts. So where does that, how do we wrestle with that here?
Well, I think there's a couple different ways to look at it. Number one is, what the important point in all of the cases is that the implied warranty exists to benefit the owners of residential property, right? Whoever owns the residential property should be able to enforce the implied warranty.
But that seems to take the policy statement this court has made ad infinitum. So
No, I
far,
don't
all
think
we've talked about is an initial purchaser and a subsequent purchaser in order to protect them from latent defects. Because at least at some point in time, somebody's going to see it. But in both of those instances, we're dealing with the purchaser. This is a unique situation now where we're dealing with for the first time an HOA. So help us understand, without having to extend that policy, is there a way to insert the HOA into the relationships we previously recognized?
Well, if you think about it, when someone buys a home that has an HOA that has common area property owned by the HOA, what they're buying is the bricks that make up the home, and they're buying the easement right to use the common area property. Okay, that's what a homeowner buys when they buy this property. They're buying the home, and they're buying a right to use the pool, the cabana, the roads, right? So they don't have title to the cabana or the pool or the roads, but they have a right to use it. So the question is, as part of that purchase, the developer agreed to build the cabana. It's a residential construction. There must be an implied warranty associated with that, because otherwise we're going to have residential property out there that doesn't have implied warranties associated with it.
Do you get the same thing by, if there's negligence in the construction, by suing for defects?
Well, negligence only applies to personal injury or property damage. You have to show a duty,
Right.
first of all, right?
Yeah, and I don't know the answer to that, because there certainly is a lot of talk about that.
Well,
if
as
there's damage.
Zambrano wrote very clearly, and this case directly responds to the argument that was made. It talks about the implied warranty as, it says the implied, and I'm reading from paragraph 31. The implied warranty protects against a builder's lack of conformity with generally accepted community standards. So that's the exact same language that the legislature used to define a construction defect. The legislature was talking about the implied warranty.
So you see, I have to say, going back to Chief Justice Timmer, I had read the Court of Appeals as basically recognizing a statutory right of action, and frankly, I read your brief saying the same thing. But, and I don't see implied warranty anywhere in this statutory language. But are you saying that Section 1361 there, that is an implied warranty? There is
That
daylight.
defines what an implied warranty is. An implied warranty is a claim that the builder did not follow a generally accepted workmanship standards. That's the substance of an implied warranty claim.
What I struggle with, though, is in the very next section, 1362E, it references implied warranty. The legislature knows how to reference within this, the very same, the Purchaser Dwelling Actions Act, knows how to reference the implied warranty, but it didn't do so in 12.
Well, it used the very definition. I mean, this is from Zambrano. I'm just quoting Zambrano. Zambrano says the implied warranty protects against a builder's lack of conformity with generally accepted community standards.
Sure, but Zambrano was written long after the statute was drafted.
But the statute used the substance of the definition rather than the label. So later in 13262E, it used the label, but in 1361-4, it used the substance of the implied warranty. If you build a building and you violate building codes, if you build a building and you don't follow good workmanship standards, all of those things would breach the implied warranty of good workmanship and habitability. So the legislature used the substance of the definition in 1361.
Counselor, can you quickly refer me to where in the CCRs it discusses the ability for their HOA to bring a lawsuit on behalf of the members?
Yeah, it doesn't say that expressly, but what it does do is it gives...
It implies it?
Absolutely, absolutely. It implies.
I'm sorry, what's the reference?
That's 8.2.3. It's on pages 78 and 79 of our appendix.
Thank you.
Yeah, and it's not surprising that the developer did not state expressly in the declaration that the homeowners could sue it for a defect. But the important point is that it didn't preclude the claim. It didn't come out and say, homeowners, you cannot sue us for a breach of the implied warranty.
Thank you, Mr. Schaefer.
Thank you.
All right, thank both counsel for your arguments and your briefing, and we will take the matter under advisement and issue a decision in due course, but we stand adjourned for the day.